Chair, we're in public session.
Thank you. Good morning, everybody. Welcome to the September meeting of JCOPE. I hope everybody had a nice summer. Two quick items of business. First, I want to welcome new Commissioner Julie Garcia. Happy to have you aboard and looking forward to working with you as we move forward. And also, regrettably, to announce that effective tomorrow, Commissioner Dawn will be leaving us. So, in my personal view, that's a huge loss for us, Dawn. So sorry to see you go. But it's been great to work with you on this. I wish you all.
Thank you so much, and I just want to say thank you to all the great staff that work very hard every day in support of the mission and goals of the Commission, and my fellow commissioners just for being great colleagues over the past 3.5 years.
Thank you. Well, again, we're sorry to see you go. With that said, attachment A, approval of the minutes from the public session from the July meeting. Any comments? Okay, can I have a motion to approve?
Commissioner Sample.
Someone?
Commissioner Sample made a motion.
Thank you. Thank you. Second?
Commissioner Sample.
Oh, okay. I didn't see Barry. Okay. All in favor?
Aye. Unanimous WebEx.
Down New York City.
Unanimous Buffalo.
In Albany?
Unanimous.
Yes.
Unanimous.
Sorry.
Okay. So that just was Commissioner Levine and Commissioner Sample.
Okay, thank you. Item 3 on the agenda, report from staff.
Thank you, Mr. Chairman. Actually, have some good things to report on our outreach. First, we're doing a training on September 20th on the new lobbying regulations as they become implemented in January. It's called Lobbying Overview Training. The response has been, to say it's been overwhelming to attend is an understatement. We've had 515 people so far who have registered or attempted to register for the presentation. While we will be doing it live, I believe in one of the legislative conference rooms in the legislative office building, we've now made arrangements to have it live streamed. So we have folks who would not otherwise be able to WebEx in, as we have commissioners WebExing in now, given the nature of that kind of communication. But we will be live streaming it, so that opens up. It makes our folks who want to participate and get involved essentially limitless. It's we're going to be doing reaching out to the participants, those people that are on the waiting list. I believe the deadline for signing up is Friday. It's Friday. And this is the first time the Commission has reached out to the lobbying community to offer this kind of live training on lobbying laws. So with the implementation of our regulations and all that goes with that, this is quite a huge undertaking. And it's going very well. Our staff has just been putting together an incredible presentation on it, and it'll be very informative. October 25th, we are doing this continuing legal education program at City Law, with the City Law program down in New York Law. Have a great panel put together. We do have two keynote addresses right now. Richard Briffo and
Professor Maggie McKinley from University of Pennsylvania Law School, who's written extensively on the constitutionality of lobbying statutes. And
that is going to be the thrust of the presentation of the CLE program, is going to be the First Amendment and lobbying. It certainly is timely, and once again, it's going to be an incredibly well-attended and very informative program. We're continuing our ongoing special training for various departments. DMV, I believe, had a special training or has been scheduled. And sorry, Megan. Today's DMV training, in line with the Commission's desire that we, and one that makes eminent sense, we try to gear our training to the issues that are confronted in agencies. That's part of what we're doing, is trying to tailor our training to the needs of agencies, looking to train per diems as well, per diem members of board. So there are a lot of initiatives that we are not just promising to undertake, but really are moving forward on. So that's where we stand now on our outreach. For the update on FDS filing compliance, Monica and Stephanie over in New York on that.
Stephanie, go ahead, Mr. Bell.
You may want to clarify.
As you'll recall, on June 4th, we sent nearly 2,800 failure to file notices across 231 agencies to certain state employees who did not file their statements by the May 15th deadline or within 30 days of hiring. Since then, as a result of substantial outreach to individual filers and agency ethics officers, staff has obtained significant compliance. Pursuant to Executive Law 9412, on August 27th, we sent 55 notices of delinquency across 27 agencies to certain filers who remain delinquent despite repeated notices and staff outreach, with copies to applicable appointing authorities. As of September 11th, approximately 19 delinquent filers remain outstanding. The notices advise the individual of the continued failure to file, including potential penalties, and provided a 15-day cure period. Pursuant to Executive Law 94A2, we posted names of these filers on our website. To the extent required, we will follow up on delinquent filers through our enforcement process. Further, on August 7th, we sent 508 confidential failure to file notices across 136 agencies to certain state employees who did not file their statements by May 15th or within 30 days of hiring. As of September 11th, approximately 54 delinquent filers remain outstanding. As you know, this year is an election year. As such, candidates for governor, lieutenant governor, controller, and attorney general are each required to file a financial disclosure statement with the commission. Generally, candidates must file within 10 days of commencing their candidacy. Filing deadlines varied depending on how the candidates were nominated. There were 32 candidates for statewide elected official positions for which we sought compliance, 5 of which were invalidated according to the Board of Elections. We sent 7 failure to file notices, 2 notices of delinquency to candidates who remained delinquent after we sent the failure to file notices. And as of September 11th, 2 statewide elected official candidates remain delinquent. Similarly, legislative candidates are required to file financial disclosure statements with the Legislative Ethics Commission, generally within 10 days of commencing their candidacy, and the LEC provides the Commission with filed financial disclosure statements within 5 days of receipt. There were approximately 287 legislative candidates for which the LEC and the Commission sought compliance. We sent 207 failure to file notices, 63 notices of delinquency to candidates who remained delinquent after we sent the failure to file notices. These candidates' names are posted on our website. As of September 11th, 29 are outstanding from that group. To date, 233 candidates have filed, 16 declined or had invalid petitions, and as of yesterday, approximately 37 candidates remain delinquent.
Great. Thank you. Any questions on that? Okay, next. Advisory opinion?
This is something that we're trying to, that staff is trying to tee up now for the commission. Nothing isn't, a draft isn't included here because the draft is not complete yet. It will be completed before our October meeting. Just as way of background, and I'll let Michael Sand to go into this a little more detail. A good deal of what we do here is field questions from state of public officials, public officers, former public officers, on what the limits are on what they can do in a post-employment situation. And as you know from going to our website, there are 100 opinions that deal with it and try to deal with the different fact patterns that we're faced with. And typically, we're able to give very solid advice. we thought it a good idea, given the accumulation of jurisprudence in this area, to come up with perhaps, and suggest to the Commission, a single decision which will take those opinions for both the 2-year post-employment bar and the lifetime bar, and put them in order and clarify them, and try to have one robust opinion which addresses how work situations have changed over the last almost 31 years. The Commission, since '87 anyway, how things have changed in the workplace, how there've been a number of changes, and try to rationalize and create something that's going to be solid guidance for public officers, and to let the public know what the rules are in that area. That is a work in progress. We anticipate giving something for the Commission in the October meeting, and we will have that to you certainly before then for discussion and for public discussion at that meeting. But Michael, if Michael's been spearheading the drafting of this still in progress work. But Michael, if you want to go into some detail.
Thanks, Seth. Good morning. So, as has been noted, the restrictions on post-state employment in the public officers law are the subject of a large majority of the inquiries that the staff field on a daily basis. We have observed that over time, some of the applicable precedent, much of it dating back to before the establishment of JCOPE, may not be as clear as they could be about the policy rationale for their conclusions and how to apply them going forward. There was an element of overbreadth in some of the resulting conclusions. Some interpretations of the statutory language may produce results that unduly restrict individuals' ability to engage in their occupation, with correspondingly little or no gain in protecting the integrity of the state government. Crucially, though, the opinion we will be proposing is not intended to change or modify the law, but rather to clarify the application of the existing precedent. For instance, the appear or practice clause of the 2-year bar. It has been interpreted as prohibiting communication or interaction with one's former agency for the purpose of influencing an official decision or action of the agency, or to obtain information from the agency that would not ordinarily be available to the public. However, the clause has also been applied to prohibit, for instance, a maintenance worker from accepting a contractual assignment with his former agency through a staffing agency, and other similar outcomes where there is really no effort or opportunity to influence the former agency. Relatedly, the backroom services clause of the 2-year bar has been applied to prohibit a former state employee from rendering services to a private entity in relation to a contract with the individual's former agency, even where the former employee would not participate in preparing work product or otherwise provide guidance in any form with the intent to influence an official decision of the former agency. Effectively, the 2-year bar is applied in cases where there is no direct connection between the employee and her former agency. Similarly, with respect to the lifetime bar, it has long been recognized as an extraordinary limitation, and therefore it's been held it should apply only to very specific acts. However, over time, an issue has developed with respect to the meaning of the word project and how the lifetime bar is applied to a single project, which is generally deemed to be a single transaction for lifetime bar purposes. While this is probably appropriate in most circumstances, applying the rule across the board produces absurd results. When applied to a very large project that calls upon the services of many professional disciplines and contractors over a long period of time, the lifetime bar can prohibit an individual from engaging in work that has no real direct relationship with the work the individual previously performed for the state. A state employee who participated in a ground-level environmental study relating to the 2nd Avenue subway project should not automatically be barred for life from participating in tunnel excavation work on that project and in a later phase, absent a showing of, quote, from the statute, both personal participation and direct concern or active consideration with respect to the tunnel excavation work specifically. The advisory opinion that we will propose will discuss the history and development of the precedent arising out of the post-employment restrictions and clarify their application going forward.
And to be clear, what we're going to do, and Michael's exposition of it is just spot on. We are not, in a way, we're going to strengthen its meaning by articulating the factors and the policies that underlie it, so that it is effective. But because situations have changed over time, within the meaning of the statute, its application has created some anomalies. These are typically some of the most common questions staff deals with, and the commission deals with. So we'll put it out for discussion, as is everything in this area. It'll be up to the commission and to engage in a robust debate and discussion on it. And you can expect to see that in our October meeting, and certainly see it before then. So, just to say a phrase, stay tuned. I don't like to say that, but that's okay.
Any comments or questions? Okay, thank you. Item 4, that would be proposed legislative amendment.
Commissioner Yates is not here today, but one of the matters he raised at our last meeting picked up on the idea that, or suggested that the law be amended to authorize the commission to disclose the status of a pending complaint before the commission under certain circumstances. As way of background, if you notice, if you go back to our 2015 report of the study commission for JCOPE, as well as other staff recommendations on legislation, there had been suggestions on opening up specifically 9-A of Section 94, which creates the sort of airtight confidentiality provisions of the statute, and opening them up. Picking up on Commissioner Yates' suggestion, and it seemed as though there was some interest, certainly on the commissioners, to discuss it, we have drafted something. It appears as B, and in essence, it says the commission may, in the public interest or under extraordinary circumstances, if the public is otherwise aware of an actual or potential investigative matter, it can authorize the chairman or staff to disclose that the matter is pending before the commission, or that the matter has been closed, or that the commission has deferred action because, as often happens, we've been asked to stand down while a criminal investigation goes forward, or some other investigation. This would also provide the subject of the investigation of prior notice of the disclosure if the individual believes that there would be some prejudice, or believes there's something the commission should know about it. It would give them an opportunity to be heard before the commission made its decision. It's here for discussion, for consideration. The legislative session is we don't know if they're coming back by the end of December, but if passed as prologue, it's that probably won't be happening this year. But it's out there as a proposed reform for discussion by the commission, and it appears as, once again, as tab B.
Anybody want to be heard? Yes.
In Buffalo?
Yeah. McNamara. Commissioner McNamara.
Yeah, it's okay. Just in the second line there, so the commission may, in the public interest or under extraordinary circumstances. I think, first of all, that's pretty vague and probably superfluous, because it almost implies that there may be extraordinary circumstances that are not in the public interest. I think it would suffice to say in the public interest and leave it at that.
That we can do.
And then secondly, down in the very last line, where we're saying that the subject of the investigation shall have the opportunity to be heard. Do we really need to provide an opportunity to be heard or an opportunity to provide input in some fashion regarding the public release of the information for the commission's consideration?
We could certainly specify, make it more specific. Yeah, the idea, as you've just articulated, is to see if there's something there out there that we should know, including whatever concerns that subject has. So yeah, we can certainly clarify
Right.
that.
Okay. Thank you. Anyone else?
May I be heard? Yes.
Yes, Marvin.
May I be heard?
Yes, go ahead.
We have.
Jacob.
Thank you. There are three specifics in paragraph D, and I was wondering whether we ought to consider a catch-all which says something along the lines of such other disclosure as the commission may deem appropriate under all of the circumstances. In other words, you will perhaps confront the situation in the future where you just don't fit within those specifics, yet it is appropriate. As a commission, we feel it appropriate to make a disclosure. So as we draft other statutes, we generally have a broad provision which leaves to the discretion of the commission a disclosure when it deems appropriate under the circumstances. I wonder whether we could discuss that.
If I, Mr. Chairman, if I just as a thought on that, I guess the concern raised by just Commissioner Yates, and that this was narrowly dealt with, was on the status of the complaint. I would just be concerned that that other disclosure might be so broad. I mean, would it be the exception that would swallow the rule on confidentiality? And I know that's a very touchy issue on confidentiality, but we are not otherwise governed by FOIL. But even under FOIL, there are certain matters that are not subject to disclosure, involving investigations and that sort of thing. And I might, I would wonder whether there might be even a perception in the public eye that this leads to leaking, or I should say leaking, or selective release of information rather than the narrow release we have, as this suggests. But I'll note that on our website, I believe our proposal, we have a proposal on there that was a staff proposal from this last year that also deals with a broader format for public disclosure of matters. But anyway, what I've done is just a concern that would strike me.
Well, the public, I think, is seeking more transparency, not less. And while this may make the burden on the commission greater, but it does provide the flexibility to act in almost any circumstance consistent with the public interest. And if the commission deems it appropriate by a majority vote to do so. But generally speaking, over the years, when dealing with statutes that confine action to specifics, we often find that we cannot act because the specifics cannot be bent, even though the public interest would suggest that. I have no strong feelings one way or the other. I have just thrown this out for discussion as a matter of drafting.
I believe that it's a very, from a staff standpoint, we're that is certainly something we could certainly live with and go forward with. You know, we'll leave that in the commission's capable hands to decide if that's, you know, the way they want to proceed as a recommendation. And I might add how we want this recommendation to go forward, whether it's something we should perhaps post on our website for further comment, incorporating the comments that have been made here, and then see where we are in October as we perhaps wind into a new legislative session, so this becomes a formal proposal. In other words, perhaps one of the things we can do is post it as we've done, and make it a forum where people can comment and have websites. Right now, or comment on the website on it. Right now, it's included in our public notice for the meeting, but maybe we let the groups out there that want to comment on it along the lines of making it a much more transparent proposal dealing with transparency. With your permission, Mr. Chairman, if there's no objection, would there be an objection if we proceed to post this on the website and allow comments to be, written comments to be sent in on that proposal? We can bring those comments back to the commission come the next meeting.
So we post now for next meeting, and we could close out discussion.
Yeah, traditionally when whether it's an advisory or a regulatory proposal or legislative, we would post the proposal, and then after the comments were received, we would post those for posterity as well. So anyone who wanted to see what the feedback was could go back. So everything would be listed on the website.
Sounds good.
And what we post on the website would contain Commissioner?
We would include Commissioner.
McNamara's.
We will put Commissioner Jacobs' comment and Commissioner McNamara's comment on those as well.
Great.
So they can see that where the discussion has commenced within the commission, and then we build on it and see where we go.
Do you need a motion?
Do we need a motion for that?
Anybody have an objection to that?
No.
I'm not sure we need a motion. There's no objection being raised, and we, as a matter of administrative, we'll put it on the carousel.
Okay, good, so let's post it, and we'll revisit this next month.
Yep, it will be brought back to you.
Thank you. Attachment C, the proposed meeting schedule.
This is for comment, planning ahead for the next 6 months, starting in January. We don't vote on the schedule, but if the commissioners could check their calendars over the next few weeks to see if these dates work. We try to accommodate holidays and the like, and we'll try to get the schedule finalized by October. So it's just for the commissioners to be aware of what dates are traditionally the ones we would be holding meetings on.
Great, so if any of the commissioners have any issues, just raise them with Seth or one of staff. That concludes the somewhat abbreviated agenda today for the open meeting. I need a motion, please, to enter into executive session. Thank you, Gary. Second.
Second.
Thank you.
Sample.
All in favor?
New York City.
Albany, WebEx, and Buffalo.
Okay, thank you. We are adjourned.
Settlement agreement. The Commission authorized steps in several investigative matters and discussed several other investigative matters.
Great. Unless there's anything else, is there a motion to adjourn?
So moved.
Commissioner Sample.
Is there a second?
Second.
Commissioner
Garcia.
All in favor?
New York City.
Unanimous.
Great. We're adjourned.
Thank you.